All right. Good evening, everybody. I am in front of Detroit Mercy School of Law, where I was in attendance until April 2nd of 2025, where they wrongfully kicked me out with no due process, allegedly. And yeah, it's all in the courts. So as of tonight, Detroit Mercy School of Law has until midnight to respond to my complaint. And I'm going to take the time to read the statement of facts to you all and just share my story. So, plaintiff's enrollment and early financial aid concerns. Plaintiff Shelby Campbell enrolled at the University of Detroit Mercy School of Law to pursue a Juris Doctor. From the outset of plaintiff's enrollment, defendants' administration of federal financial aid raised concerns. Plaintiff and other students were informed that federal financial aid funds could not be used to purchase required textbook, despite such expenses ordinarily being included within a student's cost of attendance under financial aid regulations. Plaintiff questioned these representations and sought clarification regarding defendants' handling of financial aid. Damn, I'm not looking at this while reading. Federal financial aid in compliance with the applicable law. Plaintiff is a parent and a primary caregiver. Defendants were aware of plaintiff's parental status, financial vulnerability, and first-generation student status, including that plaintiff lacked family financial support. Representations regarding cost of repeated coursework. During plaintiff's enrollment at the University of Detroit Mercy School of Law, defendants made specific representations regarding the financial aid treatment. Oh my gosh, the ground is dirty. Repeated coursework. Phil Kraus, a senior administrator with authority over academic advising and student enrollment matters, informed plaintiff that certain repeated courses would be provided at no cost. Kraus communicated this representation directly to plaintiff during an in-person meeting in his office in the context of advising plaintiff regarding academic progress and course repetition. At the time these representations were made, defendants published student handbooks and academic materials likewise stated or reflected that repeated coursework under specific circumstances would not require additional tuition payment. These representations were conveyed to students as institutional policy and were relied upon by plaintiff in making enrollment and academic decisions. Defendants exercised exclusive control over tuition, billing, application of federal financial aid funds, transcript notation, and internal academic record keeping. Plaintiff had no independent ability to verify how repeated coursework would be billed or recorded other than through defendants' representations and other publications. Relying on these representations, plaintiff remained enrolled repeated coursework as directed and continued to apply federal financial aid toward her education under the belief that repeated courses would not result in additional tuition charges or adverse academic consequences. After plaintiff raised concerns regarding grading practices, financial aid administration, and institutional compliance, defendants altered or applied billing and transcript practices in a manner inconsistent with the prior representations. Defendants assessed tuition and applied financial aid funds to repeated coursework despite earlier assurances that such courses would be provided at no cost. Plaintiff later learned that defendants modified or revised handbook language and internal practices after her removal from the program in a manner that obscured or contradicted the representations previously made to her and other students regarding repeated coursework. As a result of defendants' representations and subsequent conduct, plaintiff incurred unexpected financial obligations, adverse transcript treatment, and disruption to her academic progress. System course grading irregularities during plaintiff's first year. During plaintiff's first year, defendants implemented a newly required course taught by multiple professors across several sections. After completion of the course, defendants altered or adjusted grading outcomes in a manner that affected a substantial number of students. More than 50% of the first-year class signed a petition objecting to the grading changes and requesting transparency and review. 36 students, including plaintiff, formally appealed their grades pursuant to defendants' academic policies. These appeals involved grading decisions made by at least 6 different professors. Despite the individualized nature of the appeal, defendants denied each appeal using materially identical generic responses without addressing the specific grading concerns raised by individual students. Defendants modified or added stages to the appeal process during its pendency in a manner that benefited defendants. I have that meeting recorded. Okay. Plaintiff's personal crisis and request for institutional support. During the summer of 2024, plaintiff was undergoing a separation and experiencing significant financial instability. Plaintiff's credit was negatively impacted as she was forced to choose between continuing law school and returning to physical demanding assembly line work. Plaintiff disclosed these circumstances to Aisha Humphrey, then Associate Dean for Student Affairs, and sought guidance regarding academic options, financial aid issues, and institutional support. Rather than engaging in an interactive process or exploring accommodations or academic assistance, Humphrey recommended only that plaintiff take a leave of absence. Plaintiff declined a leave of absence because it would further delay her progress towards graduation. Fall 2024, academic difficulties and grade dispute. During the fall 2024 semester, plaintiff inadvertently failed to complete required quizzes for her constitutional law course. Upon realizing the omission, plaintiff promptly contacted the professor to seek guidance regarding whether the issue could be addressed. In January 2025, plaintiff was notified that she had failed the constitutional law course. Plaintiff formally appealed the failing grade pursuant to defendant's academic policies. Defendants denied the appeal without providing a substantive answer. Plaintiff requested clarification regarding how the grade was calculated, including how a numeral grade of 1.5 was derived. Defendants refused to provide an explanation. Plaintiff thereafter submitted a Freedom of Information Act request seeking records reflecting how the grade calculation was determined. Defendants did not provide a meaningful response explaining the calculation. Plaintiff further questioned why, if the course failure rendered her academically deficient, she was nonetheless permitted to continue receiving federal financial aid in subsequent terms without being required to pursue a satisfactory academic progress appeal, as would ordinarily be required under federal financial aid regulations. Defendants did not provide an explanation. Escalation following plaintiff's protected activity. Following plaintiff's appeals and continued inquiries regarding grading and financial aid, plaintiff again sought assistance from Humphrey, who was aware of plaintiff's family circumstances, financial instability, and first-generation student status. Humphrey responded dismissively and did not offer support, accommodations, or guidance. Plaintiff continued reviewing her academic records and identified discrepancies in transcript formatting and grade notation that differed from semesters in which she had passed all courses. Plaintiff requested clarification regarding on how her constitutional law grade was calculated, including how a numerical 1.5 constituted a failing grade. Defendants refused to provide an explanation. Instead, defendants warned plaintiff that she could be charged with unauthorized practice of law for assisting her mother with formatting pro se court documents in an Illinois child support matter. Plaintiff's mother contacted Humphrey directly to confirm that plaintiff was not representing her as an attorney. And guess what? My mama got 17 motherfucking grand. Or maybe 19, and then she gave me 2, I think. Shout out my mama. Okay, anyways. Social media, disciplinary action, and involuntary medical leave. Plaintiff later learned that unnamed individuals had raised concerns regarding her conduct. Plaintiff publicly criticized these allegations on social media. Humphrey asserted that a meeting regarding plaintiff's conduct was mandatory, then canceled the meeting and stated plaintiff's speech was harmful. Professor Andrew Moore authored or contributed to allegations that plaintiff violated the Community Standards Code based on her speech and advocacy. Aaron Archard, Associate Dean of Academic Affairs, damn, I'm fire, issued a formal notice of community standards violation, initiating disciplinary proceedings and scheduling a hearing. While the disciplinary proceedings were pending, Humphrey placed plaintiff on involuntary medical leave. The involuntary medical leave was based on alleged mental health concerns using non-diagnostic labels such as manic or paranoid, while expressly acknowledging that no formal diagnosis had been made. Oh my God. I don't know if you guys heard that, but a car just fucking... Okay. Defendants did not conduct an individualized medical or psychological evaluation, did not engage in an interactive process, and did not provide plaintiff with a meaningful opportunity to contest the allegations before removal. Upon imposing Involuntary medical leave. Defendants canceled the disciplinary proceedings. Defendants conditioned plaintiff's return on obtaining mental health clearance and imposed restrictions on plaintiff's speech, including demands related to her social media activity. Plaintiff was barred from entering the law school building and instructed to arrange a public safety escort to retrieve personal property. Financial aid reporting, withdrawal status, and refund irregularities. Following plaintiff's removal, defendants reported plaintiff as withdrawn from the university rather than on leave of absence, triggering federal student loan repayment obligations. Approximately 1 week later, plaintiff was placed on a financial aid refund list, despite plaintiff not having paid approximately $19,000 in tuition out of pocket. Main campus financial aid personnel. Okay, right there. Sorry, guys. That the personnel informed plaintiff that the refund related to federal financial aid funds contradicted representations made by the law school. Defendants offered to release plaintiff from the program and award academic credit if she agreed not to return. At the time of defendant's actions, plaintiff had completed approximately 67 credit hours and planned to graduate in November of 2025. Denial of required clinical education. Before plaintiff's removal, she applied for participation in a required law clinic. Rebecca Nowak declined to assist plaintiff and advised her to reapply, like a job, despite clinical participation being a mandatory graduation requirement. Defendant action denied plaintiff access to required clinical education and prevented timely completion of her degree. Reporting tax documentation and necessity of filing. After her removal, plaintiff retained access to law school resources and conducted extensive research. God, I cannot talk. Research into defendants' financial aid practices. Plaintiff reported her concerns to multiple oversight agencies. In August 2025, plaintiff received correspondence from the IRS fraud hotline instructing her to submit documentation related to defendants' conduct. During the 2025 tax filing season, defendants refused to provide plaintiff with Form 1098-T. Instead, defendants stated that plaintiff's tax information had been updated for 2024 and instructed plaintiff to consult a tax professional. Oh, God. So y'all can't see my hairy legs. You can just see the dirt on them. Okay. This refusal directly impacted plaintiff's ability to comply with federal tax obligations and obtain education-related tax benefits, further exacerbating her financial harm. Plaintiff had intended to resolve these matters without litigation and initially relied on counsel to pursue her claims. However, plaintiff's retained attorney, who was responsible for representing her interests, is now under investigation by Attorney Grievance Commission in Michigan. Case number ACG pound or whatever, hashtag, whatever y'all want to say, 25-2449. Plaintiff previously entered into a settlement agreement with defendants while represented by counsel, the enforceability of which is disputed. And California is investigating them. So, plaintiff previously entered, okay. In light of defendants' continuing conduct, the refusal to provide required tax documentation, the ongoing financial and regulatory consequences, and the absence of effective legal representation, plaintiff determined that immediate legal action was necessary to preserve her rights, prevent further harm, and seek accountability. Accordingly, plaintiff brings this action now, as continued delay would compound the injuries already suffered and risk the loss of statutory and procedural protections. And then I have 13 causes of action, which count 1 is ADA Rehabilitation Act. Count 2, the Michigan Persons with Disabilities Civil Rights Act. This is what I say all of my the issues fall under these laws. Count 3, failure to accommodate. Count 4, unlawful medical leave / procedural breach. Count 5, retaliation. Count 6, breach of contract. Count 7, implied covenant. Some of these are legal terms, guys. I don't know what the hell it means until I read the case, because I don't do contract law like that. Well, I clearly don't do any law like that. Okay, count 8, denial of clinical education. Yeah, that was some fucked up shit. Like, I even worked with not even professor, Rebecca Nowak at a expungement clinic. And she was so rude, acting like she knew more than this person that was a paralegal that worked at a law office that solely um, represented people like that to get things expunged. Yeah, the expungement laws in Michigan suck. We need to change them. Count 9, fraud and misrepresentation. They changed all of their policies after I left. Aisha Humphrey's not there. Phil Krause isn't there. Oh, let's see. Count 10, unjust enrichment, where they benefited off of my struggle. Higher Education Act, which I'm just declaratory and injunctive relief only, where I want them to follow the fucking laws because they just weren't. Count 12, negligent supervision, because I disclosed to them what I thought he was doing, and instead of taking me serious, they kicked me out and called me crazy. My frontal lobe would fully be removed if this was 1920. Count 13, intentional infliction of emotional distress. Everyone was talking about me at the school, and like, I didn't care. That's what I wanted. I wanted them to see what happened to me, and it scared the fuck out of everybody. And you're a bunch of future lawyers, and y'all did nothing. Like, I can't wait for this to come out. It's hilarious. Okay. Prayer for relief, blah, blah, blah. So basically, I'm requesting a jury trial, and their response is due tonight. And instead of filing a motion to compel arbitration and stay until that is decided in federal court, they did that March 25th. Their answer is due April 13th. I answered their motion, my opposition. So that is on the docket. I filed it at like 1 this morning because I stayed awake all night. And if they don't file their response, I would like to know their reasoning. I'm a single mother who has no family support, embarrassed, was kicked out of fucking school, in a master's program, running for Congress. Why could you not respond? So, Sarah, I will be waiting. Should I twerk? I can't twerk. There's too many people. I'm not that much of a baddie. Okay. Yeah, not that much of a baddie, guys. So, yeah. Fuck y'all. I ain't going away. You shouldn't have done this shit to me. Cause I ain't got shit to lose.